Welcome back to the Realtor Diaries. My name is Elijah McGowan with the Jacobi team at Century 21. Always with me is Kim Jacobi, also of the Jacobi team at Century 21.
Yes, and we are dying to get submissions. We want to hear your stories. If you have a real estate story that you want to share, just write it up for us and send it to our email, which is the Realtor Diaries podcast at gmail.com. And please like and subscribe to our podcast. We would greatly appreciate it.
Thank you. And today's topic is probate.
That's right.
And learning a lot about that. But of course, we aren't lawyers. We aren't the experts in this field. No. But yeah, I think we had a really good special guest.
Oh my gosh. I learned a ton.
Yes.
Yeah, it was really good.
I hope you guys will enjoy our special guest as well.
We'd like to introduce our guest today. This is Tara Campbell. She is an attorney, and she works with Dana L. Campbell Attorney at Law here in Chico. They do estate planning and administration attorney. Mm-hmm. They do trusts, wills, power of attorneys, special needs trusts, and estate and trust administration. Yep. And we're so fortunate to have her here today. She's been working with Dana Campbell, and this is Tara Campbell, so you can see.
Yep, it is family business.
Yes, mm-hmm. we love that.
And we are today ranked in order of knowledge and experience.
And as you know, our topic today is specifically about probates. Mm-hmm. And Tara actually passed the bar in July of last year, 2024, but has been working with her mother in basically this area since 2020.
Yep, I have.
So yes, we're excited to have you here and talk about probate.
Yeah.
So what's your burning question that you have?
Oh my gosh. Well,
for Tara.
It's hard to know where to start. So probate, someone passed away.
Right.
And so I guess my first question is it more common for the realtor to be a part of the process beforehand, or do they come to you first?
I would say they should come to us first.
Okay. Uh-huh.
Whether they do or not is always an open question.
Okay. Yeah.
And I mean, to be clear to your listeners, probate's really specific. It's a court occurrence that involves either somebody who only had a will or who had no plan at all.
Oh, okay.
It's very common also to have trusts, and with trusts, you don't go through probate. So with trusts, the realtor can be involved a lot earlier in the process.
Yes.
Yeah.
Because as long as your trustee has authority to sell real property, they can jump right in.
That's right.
Okay, so if you just have a will, then
or nothing at all.
Or nothing at all.
Mm-hmm. Yeah. I mean, if you have a will and your estate's really, really small, you can bypass it. But most people who own property are going to be over that threshold because it's an estate value of $208,000, excluding all your debts. So fair market value of $208,000 or higher.
It can be very easy to,
especially in this area. Yep, most people who own property, other than maybe a vacant lot in Paradise,
right,
would be above that threshold,
unless they had zero debt.
Well,
no, it's the fair market value, regardless of the debt.
It
could be, so you could own property that's worth $495 and you have $450 of mortgage on it. For probate purposes, it's worth $495.
Got it.
Okay.
Right.
And just to clarify, does that mean even if there is a will?
Right. And this is a common misconception. Wills don't avoid probate. Wills just make the process easier by saying how you want things to be distributed.
Oh, it just clarifies.
Right, because otherwise it's in the code exactly who's going to get it, how they're going to get it.
Oh.
So in a will, you can say, well, no, I don't want it to go the default way. I want it to go this way. But it still has to go through all the court procedures.
So there's a basic set of rules that everyone follows baseline.
Right.
And then there's wills which clarify what you want.
Exactly.
Instead of the normal rules?
And they assert some preferences. So if you name an executor in your will, you're saying who you want to manage the process.
Okay.
If you don't have one, somebody comes forward to the court and says, I think I'm qualified to do the job.
Oh, yeah.
Right? So it does ease the process to have a will, because you have somebody designated to come forward, start the process,
Nice.
make it a little easier. But yeah, either way, to your original question, hopefully they would come to the attorney first, because and in any probate proceeding, you have no authority to sell the property until well into the court process.
Okay.
Yeah. So maybe walk us through, like, I guess, a very typical, and in your mind, you're like, there's nothing typical. Okay. So let me, I guess, set up a scenario then. Okay. So mom and dad passed away. Does it matter separately or together?
We would be looking at the last person who passed.
Okay. Let's say they both tragically died in their sleep at age 97 on the same night. And they have they have 3 adult children, and there's like 12 grandchildren, and they own one home that's completely paid off. Let's say it's worth $300,000.
Okay.
And they have no debt and no other belongings or stocks or investments. They just have a house full of stuff.
Well, that's an interesting question, because you've actually given me another option other than probate.
Oh, dang it.
So let's complicate it and then back up.
Okay. So what will be the basic process?
Let's take your scenario, and let's say there's also investments accounts to deal with. Okay. So there's more than one thing going on here. And they have a will or they don't have a will, but either way, they've named all their kids as the one who's getting it.
Yeah. Okay.
So intestate, it would go to the kids by default. In a will, they've named the kids. Either way.
Wait, what does intestate mean?
Testate means no will, no trust. You didn't have a plan.
Okay, got it.
Legally, you didn't have a plan. Maybe you had one in your head. Maybe you told your kids, but you didn't legally have a plan.
It never got written down.
Right. I imagine that can get a little muddy if they told people it's one thing but didn't write it.
It's tangent, but it's a good thing to know. Less than 30% of people have any form of estate plan.
Yikes.
So theoretically, 70% of people would end up doing an intestate proceeding under probate.
We need to send this episode to every single one of our clients that own a home.
And related to that, when you start a probate proceeding, whether it's with will or intestate, you're now on the public record. So everything that happens is now public record.
Oh, right.
When people do a trust, it's private.
That's right.
The public record is the will says everything goes to the trust, and it stops there.
Yeah.
Okay.
Right. So that's the other way people got it. But let's take your case. There's a house. There's some investment accounts. They've got a straightforward one. It's all going to the kids, and nobody's going to argue about it. Right? Right.
No
all the kids agree.
Yeah.
Right. What's going to happen is either one of the kids is going to step up, or one of them, somebody was named as an executor. Mm-hmm. They're going to go to the courts or to an attorney who's going to prepare a petition to file with the court. And it's a petition for probate proceedings.
Okay.
The very first part of the petition is where you step forward and you say, we believe the estate is worth this much. And I believe that I am the right person to manage this. Right.
And you're saying this to a judge?
To a judge and a hearing. Judges, research attorneys and staff are going to do the research. They're going to see if, that person has financial crimes or other problems that would make them not a good person to administer an estate.
Yeah.
And assuming there's no problem, they're going to appoint them. They're going to give them a letter of administration, which says, you now have the authority to begin on this proceeding. Mm-hmm. That doesn't give them authority to sell the house. It gives them authority to go talk to everybody and find out what the assets really are. Because prior to that point, no bank, no realtor, or anybody else should be talking to them. They're just a random stranger.
Yeah.
Right?
Okay.
So then at that point, they're going to figure out what all the assets are, and they're going to reach out to the probate referee. Butte County has one. Actually, it's Jane Dolan, and she covers 4 counties.
Oh, okay.
And you reach out to her and you say, here's what we think the value of the estate is. Here's the accounts we're aware of. Please value them officially.
Mm-hmm. And the attorney, the probate attorney doesn't do that? That's up to the...
In the probate proceedings, it has to go to the probate referee. And it could be the attorney doing it on the family's behalf, or it could be the family doing it themselves.
Okay, got it.
Kind of comes down to how much they want to do on their own and how much they'd rather just pass things off to the attorney and say, hey, take care of it for me, and how capable they are. Right. Some people very much need the attorney to hold hands and do everything. And some people are like, give me a list. I'll check in regularly. We'll do this.
Nice.
Right. Okay. So it goes to the probate referee. It takes anywhere between 3 and 6 months for her to value the property as of the date of death. Then it goes back to the court with evaluation. The court says, yeah, this looks reasonable. Mm-hmm. And then the court authorizes the executor of the estate, who's now the administrator, to deal with the distribution off of the assets. Can't give them out yet, but now we can figure out who the heirs are, who everybody should go to. Oh my goodness. And if the property needs to be sold, because if it's going to the 3 children, the administrator could just be doing deeds to transfer it, as tenants in common to the 3 children.
Yes.
Right. And then it'd be, if that's the route they go, then you wouldn't be selling it till the children get it and agree.
Yeah, then they can decide.
But they could also have a lot of debts in the estate and they need to pay off the debts, so they need to sell the house. Or the kids have all said, we don't want the house, please sell it.
Yeah.
Right? Once that's all figured out, they have to go back to the judge, say, I would like authority to sell the house.
Okay.
Right? And then the judge says, yes, you can sell the house. Only at that point can they now go through the process of selling the house.
So that was 3 court hearings.
Yes. And I would say on average, at least 6 months into the process.
Yeah.
At least.
And a chunk of that is with the probate referee figuring out things.
Yeah, waiting for valuation. And I mean, it's not that they can't have reached out to the realtor in advance. Right. Honestly, we often ask a realtor to do a simple valuation that we can include in the documents that go to the probate.
I've already do a couple of those.
Yeah.
Over the years.
It makes her job easier. She's got kind of a starting mark of what a realtor thinks it's worth.
Yeah, that makes sense.
And theoretically, if the process is clear and you all know that you're heading towards a sale, the administrator could be working with a realtor in advance to get the house ready, get it landscaped and cleaned, and everything that goes into preparing a house.
But as a realtor, what we want to know is, do they have that letter of administration?
And
from the judge.
Right. That would tell you that you're talking to the right person. Yeah. And then do they have the order to let you actually list it and put it on market?
Yeah.
Right.
So 2 steps.
2 steps.
No.
Well, I mean, a lot of steps in between.
But 2 steps from the realtor's point of view. Am I talking to the right person?
Yeah.
And do they actually have authority to do this?
And then the court will use what Ms. Dolan set as the value. And so we'd have to list it at that value?
No, that is a value as of the date of death and is for valuation purposes for inheritance.
Okay.
So it also determines the fee that gets paid to the attorney, the administrator, and the probate referee, because it's a statutory percentage.
Got it.
Oh. And that confuses people sometimes. You know how the market fluctuates.
Absolutely.
Yeah.
Let's say that this process took a year and a half because the kids weren't sure whether they wanted it or they wanted it sold, or there was a challenge. Right. And it was $495 when she valued it, and then the bottom falls out of market and it's now worth $350. Or market
really bad.
Right. Yeah. Or the market booms and it's now worth $550.
Yeah.
Right. For valuation purposes in the court docs, we're talking about, what the initial estimated value was, and then we're going to have to show the difference in the final submittal after the house sells. So if it dropped out and sold for $100,000 less, because maybe it wasn't the market, maybe the factory went in next door and nobody wants to buy it.
Yeah,
right?
something
changed.
Yeah. So you're going to have to show why you did due diligence to get the best reasonable price out of the property, as opposed to just, selling it to the first one who asked.
Yes.
And if it went up, great. Did you same question? Did you do your due diligence to get the best out of it, or did you know it was fair and you just went easy? Because it's sort of that
Oh, okay.
Right. That's the tricky thing. Is often our first offer is the best offer,
even if it doesn't seem as good as we would like it to be.
right?
Right. But that's all reasonableness standard. Most of the court proceedings are reasonableness standards. So if the first one was the best offer, they can also show that here's all the parables.
Yeah.
They're selling right around us.
Yeah.
And there's holding costs to keep a property on the market.
That's true.
If this is really close and it's going to cost you, $2,000 a month to keep a property insured on a maintained on the market.
Yeah.
There is a reasonable argument for taking that number.
And what about the mortgage payment? Let's say there's still a mortgage. Like, is anybody paying that?
It is supposed to be continuing to be paid from the estate. Now, that said, let's take a one where they have no financial assets, where they had really minimal financial assets, and there's nothing left to be paying mortgage.
Right.
Yeah.
It creates the pressure for foreclosure, but the mortgage companies also have to hold for a reasonable period when it's in probate, right?
Okay.
They can't supersede a probate proceeding.
Got it.
Now,
That's what I heard.
They can't foreclose if it's in the probate process.
as long as it's being reasonably managed.
Yeah.
If the kids are duking it out for 6 years,
Right.
at some point the judge is going to order the sale, and
Yeah.
they're going to have to live with it.
Right.
You know?
So I don't mean to cut you off, but what was the longest probate involving real estate that you ever experienced?
We have one open that's been going 6.5 years now.
Oh my gosh.
But it's less about the problems and more about the fact that she had investment properties, and many of them are commercial, and you can't sell out under a commercial lease.
Yeah.
Oh.
Right?
Yeah.
So we have a period of, we can sell this one next year, and in 2 years we can sell the other one.
Yeah.
And the year after we could sell these 3.
And the lease can't transfer to the new owner?
They can, but often people don't want to buy it with a lease on it.
Got it.
Okay.
Yeah, depends. You know the market. Like
Yeah.
sometimes people are totally looking for an investment property, and if it comes with tenants, great,
As long as the tenants are paying a good fair market value.
right? And sometimes that's the problem.
Right.
Tenants don't want to go up to fair market
Yes.
value, so they have to wait.
That is very often the case, at least for properties that have been held for 30 years.
Yeah.
Right.
Tenants have a great rate and they never want to leave, but
And then the previous owner never bumped up their rents
yeah.
as they maybe.
Or brought them up not enough.
Yeah.
Yep. Yeah. And so, you get the combination. I did want to say I mentioned earlier there's another option.
Yes. I was gonna,
And this is brand new this year
okay.
and very misunderstood. So I love the opportunity to clarify.
Please teach us.
You probably saw the news a couple of years ago. They talked about we're going to raise the probate threshold. We're going to make it really easy to transfer the primary residence.
Okay.
And then, like legislators do, they digged around and changed this and fiddled with that and, wrote this part out.
Yeah. Yep.
And the final bill that passed and went into effect now makes it different, not easier.
Okay.
There used to be a petition to determine succession to real property, and you could do it for things that were in smaller value, but not small enough for a small estate proceeding. So things under 60,000 have a small estate proceeding that's kind of expedited. That'd be that law in paradise.
Yeah.
Oh, okay.
Right.
Okay.
But we used to have a petition to determine succession that we could do. Well, they overwrote the code section with the new petition that only lets you deal with the primary residence.
Okay.
In that petition, the primary residence is able to use it, opts to use it if it's under $750,000 in value.
Okay.
Great in our area.
Yeah.
I don't know if that works in San Francisco.
No.
Right.
Probably very rarely.
But in this
Exactly.
area, if you opt for that petition, you can actually separate it from the rest of the probate
Okay.
and do
Including the debt?
The debt, it stays with it,
Okay.
right?
Okay. The mortgage
Because it
rolls with the.
yeah.
As I don't mean the debt of the home, I mean the debt of the estate.
Yes,
Good.
to a certain extent.
Okay.
If you can show that there's enough other assets to cover the debts of the estate, you can separate them.
Okay.
Right? The idea is when you have really complicated other stuff in the estate, it's going to take a while, but it's very clear who's going to inherit the house.
Yeah.
You can separate them, do this petition to transfer the house, and then deal with the rest of the probate later.
Okay.
Sounds good in theory,
except
the requirements that they added when they created this petition to determine succession to the primary residence require you to go through a probate referee, just like in probate.
Okay.
Require you to notify more people than you used to have to notify, which creates more potential objections than you previously would have had. So it's still, you still have the 3 to 6 months to deal with probate referee. It's still a court proceeding, and you have the possibility of more people coming out of the woodwork.
Gosh.
Oh.
So you have to be really careful. So like maybe your situation where you have this person in a 6.5 year probate.
Yeah.
Maybe if they would add a single family home, that would have made sense.
Yeah. If they had a will. Yeah. And their will was being contested on other fronts, but it was really clear that their one child was to get the house.
Right, right.
Okay.
It might have been worth separating it out, dealing with it. Yeah. Letting the child inherit the house, going on with that. Yeah. Right. Whether the child's going to keep it or immediately sell it.
Right. Or whatever they do with it.
Right. Yeah. And there's the fact that you're asking an attorney to have 2 proceedings going. Yes. So you're paying fees on 2 different things.
Double. Yeah.
And there's a statutory rate on probate, and this would be, and usually your attorney's hourly rate. Yeah. Mm-hmm. Right. So depending on the value of the property, a $700,000 property, it's probably worth it to separate it. Yeah. Right. $250,000 property, you might be better off leaving it in probate from a cost perspective.
Yeah. May I ask, as you can tell us, what is the statutory probate cost? Is it a percentage of the?
It's a percentage of the value of the estate, which is why that probate referee is so important.
Yes.
And it's a tiered system, so or it goes up at certain landmarks. It goes up and up.
So it's not just an easy 10% or something like that.
No, although I've done the math on it, and at the bare minimum, so a $209,000 probate, you're starting at just about $7,000.
Okay, your fees. Okay. That's just the probate.
That's the fee to the attorney.
Got it.
Under the code.
Gotcha.
Right, which is also why you pick the attorney you like, because they have to charge you the same.
Yeah.
Right.
Yeah.
Oh, good point.
Yeah.
Good point.
But comparably, if somebody had a trust on that and it was a straightforward property transfer, right, that might have cost $2,000.
But to make the trust, yes.
So, not to make the trust, to do the administrative side, to do the paperwork, to do the filings, to do the things you have to legally do. It might have been $2,000 or $3,000 to administer that instead of start at 7 and go up.
Right.
Right. Good point. So, 6 one, half dozen the other. Do you invest a little more in your trust up front?
Yes.
Or do you pay for it on the ends? Arguments both ways.
Okay.
I think, for the family's sake, getting that trust in place, clearly saying who you want the executors to be.
And trustees in a trust. But
trustees, sorry.
That's okay. We have the law is great. We have executors, administrators, and trustees, depending on whether it's intestate with a will or in a trust. They all have basically the same job.
Yes. Okay. So a trustee was named in a trust.
Right.
An executor is named in a will. Mm-hmm. And an administrator is named by the court in probate.
Correct.
Did I get it right?
Yes.
Nice.
That's like the first time in my entire career that I understand now.
Close that was.
Now, are they all beneficiaries when they're getting things?
Not necessarily.
Not necessarily.
I didn't think so.
It could be devisees or legatees or beneficiaries.
Oh, no.
Oh, my gosh.
Yeah.
I'm like, devisee, what are we talking about here?
Yeah.
Divas?
Devisees.
Divas. Yes, exactly.
I always think of it as Devises start with D, so it's gifts after death.
Oh my gosh. Devises. What is the root of that word?
To devise is an old way of saying to gift.
Oh, wow.
Okay. I was thinking divide, but no.
No,
it's just devise.
I devise upon you my classic car.
There you go.
Right?
Interesting.
Yeah, I love we just take the old words and we hold on to them and say, no, you can't take those away from us. Just keep using them.
And then something new happens and you choose a new old word to hold on to forever.
I still get confused sometimes between like who is the lessor for a lease, right? The lessor and the lessee.
Yep.
Right? Or your realtors, you're familiar with, people hold their property in fee simple.
Right.
Fee is an old word that comes from O as in feudal. The word comes all the way back from that far.
Which is crazy.
Yeah, I'm lost, but that's okay.
Right.
I remember learning about fee simple in real estate class, when you're taking your classes and then the day you start actually working in real estate, you never, ever use that term ever again.
Ever again.
Nope.
Because you looking at the title on the deed, and never does the title on a deed say John Smith in fee simple.
No, it's not.
You don't see that. And so I'm like, what's the definition of fee simple? I don't really know. I can't remember.
I haven't read that word in 17 years.
I know. Well, no, you read it when you were studying for your real estate test.
I did. But I don't think it was on the test.
Oh, wow.
To own outright without restriction.
There you go.
Yeah, how would you use that in a sentence?
John owns the property in fee simple. He doesn't have any life estate tenants or things on it like that.
Yep.
So he doesn't owe any money on it either. Or can you own something in fee simple?
You can have a mortgage separately. So mortgage for probate purposes, liabilities or debts are held independent of the properties. So but you wouldn't have it in fee simple if there's conditions on it. If it has conservation easement on it, it's not in fee simple anymore.
What's a conservation easement?
It's a special thing you can do where you restrict the usage of your property for environmental preservation purposes.
Like conservation.
Right,
Okay,
exactly. And so what you see people do is they put the conservation easement on the property, and then when it gets passed along, it can only be sold to somebody who's going to respect the conservation easement. Yeah. They can't just go build a house on it because they like it.
And there are some properties, especially like up in the foothills and things, that they have those on there.
Yeah. It's a growing thing, and I think there's a growing number of people feeling like we need to preserve our open space.
Yes.
There you go.
But I imagine, I haven't actually dealt with trying to sell something with the conservation easement on it yet. I imagine it'd be challenging.
If it's in the right location, then you're going to attract buyers who want to live in that type of location.
Exactly.
But if, let's say that somebody in the middle of town here in Chico, they happen to own two lots. One has a house on it, and then the other parcel is completely vacant.
Right next door, like a large yard.
Right. But it's like in the middle of downtown or whatever. If they put that conservation easement on that vacant lot,
nobody's ever going to buy it.
They're not going to ever be able to sell that lot separate. It'll have to always go with the other house, and then it's not going to be worth very much.
Right.
Yeah.
Exactly.
Yeah, and we're starting to see more and more of people who have, 80 acres in the hills behind Oroville, and there's a barn and a house on it.
Yeah.
And they add the conservation easement, which means the barn and the house are the only structures that can stay there. Yep. They were already there.
Yeah.
Right.
Wait, and so would that prevent repair or replacement of those structures?
You can maintain the existing structures. So
maintain
what if it burned down?
Repair.
You could probably replace it.
Okay.
Barring other governmental restrictions, but you couldn't expand the footprint of it only once, right? So if all you want is a house and 80 acres that you can ride your horses on and wild animals can be free, great.
Perfect for you.
Perfect. If you want to add a house for your mother-in-law, you might run into problems.
Yes. And this is like forever and ever?
Forever and ever. I say it with asterisks. Eternal.
Of course.
Eternal attorney actress.
There will always be the exception.
It's funny. At least in U.S. law, forever's not forever unless you're talking about a cemetery.
Really?
Yes. A cemetery is forever.
And anything else is
It's
sometimes
not potentially forever.
You mean land use wise?
Yeah.
Once a cemetery is declared a cemetery, it can never be
the code says that it must be maintained for the cemetery in perpetuity.
Wow.
Yeah.
That's a dangerous term, but
yeah,
I mean,
it's also why we have all the issues with the Indian cemeteries. Once you find one, you now have to maintain it in perpetuity because it was a cemetery.
What it is and where it is.
And it's created this such a tangent, but it's created this weird niche where you have people working to designate their lands as natural burial cemeteries.
Oh.
And then they themselves are buried on it.
Oh.
And it's the only way to create a truly permanent conservation on it.
Oh my goodness.
Because now it's a natural burial cemetery.
Oh, wow.
Mind blown. Because I have heard of people doing that, but I didn't realize that was why.
That's why, and it's challenging because.
But you can't do that just in the city limits or anything.
No,
like that.
you can't, and there's a lot of rules.
Yes, definitely.
And somebody has to be willing to take on the maintenance of it.
Right.
So you can't do it if you can't find somebody who's not willing to operate it.
Yeah.
True.
Right.
One grave cemetery.
Right. Now, if your kids are willing to take it on as a family business to forever maintain this natural burial cemetery, and you have to allow other natural burials on it.
Oh,
that makes sense.
Yeah. But
Crazy.
anyway, such a tangent from probate. But hey, kind of a fun one.
Exactly.
I know. I mean, we're talking generally when people pass, there's things that can happen. So
yeah.
Well, gosh, we could probably talk for hours, but I think this will be a good time for us to stop. I'm sure we'll have you on again in the future.
Just be a little more focused.
Yeah.
Or maybe not.
Yeah. Thank you so much, Tara, for joining us. We've really enjoyed this.
I've really enjoyed this too.
And now it's time for the news.
Yes.
So, because our guest is so full of knowledge about a topic that we are not. I mean, she's a lawyer.
We're not lawyers.
No. Even though, we can help someone sell a home in probate, it's still just about selling the home for us. We know the basics. So anyways, we thought that it would be best to really kind of use this time to give more information, maybe some summarizing and some commentary based on what you just heard, because it was a lot.
Yeah. And probably the most interesting thing and probably one of those relevant parts was like when we should kind of be getting involved.
Yeah.
And that's after we know who we're talking to is the right person. They have like the court document showing that they're the administrator, the executor.
Yeah.
And then another one.
The administrator.
The administrator, that's the right term.
Yes.
And then another document from the court saying, okay, so you can't sell the house.
You can sell the house, like a court order saying you can sell the house.
Yeah. And what I didn't quite understand from it was if it's you can sell the house or no, you are going to sell the house, which I believe it's still not required unless they need to sell it to cover debts.
Yeah, it was you can, because then she talked about how maybe the best thing to do, well, let's say that the administrator is one of the siblings and there's two other siblings. Maybe they just all decide as siblings that they're just going to put the house in each of their names.
Yeah, tenants in common.
Instead of selling the house through probate. But she said that's only if the estate doesn't have a bunch of debt.
Yeah, we did talk about that.
If the estate had debt, then you have to sell the house or enough of the estate to be able to pay off the debt.
Yes.
In probate. So
that's probably the most relevant portion to us in that talk.
Yeah.
Although it's all very important.
Yeah. So I kind of felt like recapping the process.
Do it.
Okay. So let's say dear mother passes away. Then
Step one
is somebody's got to kind of look for a will, look for look for documents on the property. And then we would say at the same time, reach out to a trust or a probate attorney.
Yes. That's a really good step one.
Yeah. Like just start there.
I mean,
Even if you find a will and a trust, reach out to that attorney.
yeah, because I mean, they are the experts.
Yeah. And honestly, like, if you don't know one and you want a recommendation to one,
Mhm.
a realtor is a great person to recommend
Yep.
a probate attorney, because we work with the ones that, you know, have experience.
Yeah, I can't say it. I don't actually. I know an estate attorney, but I don't think she does probate. I think it's like trusts mainly. But
she would know.
exactly,
Yeah.
like
Yeah.
there's a network there.
Yeah. I know pretty well two probate trust estate attorneys.
Mhm.
And then probably like another two or three names.
Yeah.
Two of them I could confidently recommend.
Yep.
Like, if you hire this person, they're going to do a fantastic job for you
There you go.
and be sensitive and caring and get the job done.
And Tara said it. Just pick the person who meshes with you the best.
Yeah.
Because it's a statutory fee.
That's right. And then after you get that attorney, let's say you don't find a will or a trust.
Mhm.
You're going to have to go through probate. Let's say you find a will but no trust. You're going to have to go through probate. If you find a trust and the trust is correct, and then you can avoid probate.
Yes.
So let's say you're in probate. The first thing is, number one, a judge is going to have to determine the administrator.
Yep.
So if there was a will and the will says so-and-so is going to be the executor of this will, then I don't want to give a number or percentage, but the judge will likely make that executor the administrator. Not 100% of the time, but
case by case basis.
Yeah.
But that is a good general guideline.
right. So then from that step, it goes to the probate referee, who in our area in Northern California, there's one person for 4 counties.
Yes, which I was surprised.
I know.
But it's just population based, I would assume.
I don't know. That's something I'd like to learn more about. Why? Why is there one? Like, is that a government set limit or something? I don't know.
That's a really good question.
I know. Like, why aren't there 100 probate referees? I don't know. Okay, so then the probate referee is going to determine what everything in the whole estate is worth.
Yep.
So the cars, the tractor, the art, all of the personal belongings, the home,
Yep.
and the debt.
Yeah, you'll get, I mean, usually before that, you'll have some general idea, but the referee, it's like line items.
Yes.
Just exactly how much each thing is worth by their analysis.
And in our area, that could take, she said in the interview, 6 to 8 months.
Yep.
So that's a long time. So then once that gets turned in to the court will say, okay, now we got this. Now, administrator, you can start working out who gets what, or what you're going to do with all the assets.
Yep. Start divvying things up.
And then then I guess you're going to turn something into the court and say, okay, here's our plan. And then the court's going to say, okay, now you can sell the house.
Yep. If it's like a part of your plan.
Right. So we printed off these forms that we've used, that realtors use with their clients when they're having to sell a home or buy a home that's in the probate process.
Yeah.
And like one of these here was the probate purchase addendum, which is basically like additional terms to the buyer's offer.
Yes.
And what blows my mind about this is that it even makes it an option. Like, I don't think it should be an option to even write an offer on a home that hasn't gotten to that step 2 of the court.
Mm-hmm.
Okay, so step 1, the court said, okay, you're the administrator, but let's say that it's on the probate referee's desk.
Yep.
And then the seller, the family's like, let's just put it up for sale. And then a buyer's like, I love it. I'm going to write a house.
You can get all the way
write a house
to
write an offer.
You can get all the way to opening escrow.
Yeah.
Potentially without having
Right, because
the
there's
court order that gives you the permission to sell it.
Yeah, there's literally a box on this form that says the sale is contingent upon court confirmation, which is a court hearing that allows for open competitive bidding for the property. This form is very complicated.
Yes.
Or it's not a bidding situation. It's just the judge is going to say, no, buyer, we're not going to let you buy this house.
Mm-hmm.
So yeah, you could write an offer and get into escrow, but it's going to be up to a judge whether or not you get it or not.
Yeah, and it could end up being. I've heard of this happening where it becomes basically a bidding process
Yeah,
at the court hearing.
right.
Judge asks, "Does anyone want to make an offer on this home?"
Yeah. Yeah, it's crazy. It says the minimum overbid price shall be an amount equal to the accepted purchase price plus 5% of that amount plus $500.
Yep. And so someone, if like,
I don't even know.
I don't even know what that situation would be, but I've heard of it happening.
I've never gotten to experience that, or I don't know anybody who's gone through that process.
Yeah, but I mean, it can be kind of scary.
Yeah. I think I've helped sell, let's see, I've done 2 listings had gone through the probate.
Mhm.
And of course, we didn't even sign the listing until that administrator had the authority to sell the house.
Yeah.
So that was all the way through all 3 court processes.
Yeah.
And then I got the listing.
Which feels like the right way to do
It
it.
is. It did. Yeah, because then we just did it like a normal house.
Mm-hmm.
We just put it on the market. We had to include some additional paperwork. And that's the other thing too, is if you are, like I just said, I represented 2 sellers who were administrators on a
Mhm.
listing. There still were some things that they were supposed to, by law, disclose to the buyer.
Yes.
And so maybe you can talk about some of those things.
Yeah. When you're in probate, you are exempt from some things, but I mean, a lot of it you're still on the hook for. Smoke alarms, water heaters, lead-based paint, like older homes or homes that don't have those things, at least for residential property, you're required to make sure they have these safety features, carbon monoxide devices.
That's
I
right.
mean, those are kind of the basics,
Mm-hmm.
but I mean, they have to like disclose a lot, whatever they know about the property to you.
That's right. So, like, let's say it was your mom's house and you're the administrator.
Mhm.
And so you're the one, filling out all this paperwork because you are listing the house for the estate. One of the forms you're going to fill out if the house is older than 1978 is the lead-based paint disclosure.
Yep, and let them know that there might be lead-based paint on the property.
Yeah, and it's literally has lines on it where if you do know for a fact, like there has been an inspection and it said this was lead-based paint, and you know that, then you have to write that down.
You gotta tell them.
But if you have no idea, then you don't have no idea, and that's
Yep.
fine. That's just how it is. But if the water heater is not strapped properly, if there's no carbon monoxide or the smoke detectors don't work, that's going to be on you to make sure those are in place before they close escrow.
Yep. And yeah, I don't know. I think it's really interesting. And I saw another one on this specific one about it's how if has been a death on the property within, I believe,
3 years.
3 years.
Yeah.
That needs to be disclosed. But on here, well, for context, generally the seller and the buyer may never even have a conversation face to face.
Right.
Like, because they have representatives who speak on their behalf and communicate their wants and
Through the
needs.
paperwork,
Yeah,
basically.
pretty much through the paperwork. But in these documents, it discusses how if the buyer wants more information about like what is happening in the probate, they should go talk to the administrator.
Interesting.
As in, the document says, like, you should send your specific questions to the administrator of the estate,
Yeah.
Mr. and Mrs. Buyer.
And how we would do that in a practical sense would be, that buyer would send their questions to their realtor. The realtor would pass it on to the listing agent, and then the listing agent would pass it on.
Yep.
So it's like
A little game of telephone.
Yeah. But if it's in writing, then it shouldn't be misconstrued.
Exactly.
So that's good. Email is good. So, the probate process is one that I hope to avoid. I know that, my parents are getting up there in age,
Mhm.
and they don't own a house. So I think that their estate is actually going to be able to avoid probate if both of them were to pass.
Yeah.
But if you have older parents
My
and
family's
they
had medical scares before.
and if they own a home and that home is not in a trust and they don't have a trust, then
Yes.
encourage them to do that. But sometimes people can't afford it because sometimes it's like $1,500 to $3,000 to get a trust put together, depending on who you hire. You can try to do it on your own. Get your own, buy the documents online and do your own trust. But at the very least, get a will.
Yep.
And state an executor.
Yep. As with a will, you can set some guidelines. With a trust, you can set the rules.
That's
honestly.
right, for everything. Yeah. So, hope you guys found this interesting as we did.
I'm really glad we did this topic.
I know, me too. And we hope to catch you on the next podcast. It's going to be a good one.
Thank you.